And then the relevant provider country came back to us and said, you know what, actually, we don't have any clue about the permit number. Do you have any more information on that? And so we went into an exchange of information between us and the provider country and us and the user. And so we asked the user if he could provide us with more information about who had issued the permit. And then we gave this information back to the provider country. And at the end, we didn't really get the last information if everything was fine, but at least there was an exchange. And so if there would have been like a breach of the legislation of the provider country, this could have been solved by informing us against. So I think the mechanism which was meant by this system had worked here, although now in this specific case there was not a clear solution, because I think then the provider country found out everything's fine. But yes, so this, for example, was one case where we had information by the provider country which came back to us to ask for further information. But altogether, we have, I think we have 41 checkpoint communiques on the ABS clearinghouse by now. And in the most cases, there were not any complaints or problems. Maybe last year we can say we had a declaration where we easily saw that the information about the research project didn't match the prior informed consent. But because the prior informed consent said, okay, we allow the research or utilization for the next 5 years, but the project already had ended. So there was a time lag, and we asked the country of the provider country directly. So we didn't go the way about the ABS clearinghouse because the information was confidential. And so and if this is the case, if the clearinghouse is not in the process because of confidential information, we can go directly to the provider country. So we explained them the case, and actually here it was not easy or not at all possible to find out if there was a violation of the respective legislation of the provider country, because they were aware of the problems, but they said, well, we have no means to issue a permit retrospectively. So we know that the permit is not for the project that has already been finished, but we think that the access anyway was not during when we already had access legislation. And we said, no, we have different information, because we have information that access took also place already when you had your legislation. And so it was back and forth and back and forth. And at the end, we really posed the question, is this what we think is a violation against your law, really a violation of your law, according to your opinion? And then they just wouldn't answer anymore. So at the end, again, we had a different opinion than the provider country, but as long as the provider country does not confirm the breach, the infringement, we cannot do
Hmm.
more. So, but there is
Yeah,
an exchange possible via those checkpoint communiques, and so the idea works.
that's interesting. I guess it was a bit of a technicality though that they couldn't go back and reissue the permit. So they, it was kind of a gray area that they wanted to. I don't know. It's an interesting case though. Yeah,
Yeah.
thanks. Does anybody else have any experience related to this? No? Okay. Thanks, Ellen. I'll just go to the next question. So when a user encounters a checkpoint and does not have an ABS permit, and they say they do not know the source of the genetic resources, what is the role of the check? What is the checkpoint supposed to do? So this is a good question that also is difficult for me to answer. But I mean, under the protocol in Article 15, we talk a lot about cooperate. I mean that parties have to take appropriate effective measures to ensure that users are utilizing genetic resources properly. So in this case, the user country may need to do some more work to ensure that the users have done their due diligence and have done the work they need to do to figure out if if really they cannot find the source of the genetic resources and if it falls into the scope of the regulations or not. So I guess I don't know if you have anything this case comes up or not, Ellen.
Um, well, we have cases where users do not know where the genetic resource is coming from. Now you have to see at which state this happens. Normally, a user will not declare due diligence if he doesn't know where the genetic resource is coming from, because the EU regulation only applies when the genetic resource is originating from a country that is a party to the Nagoya Protocol. So if it's not clear where the genetic resource comes from, then the regulation does not apply. But of course, we would ask what he had done to find out about the origin. And if the answer is plausible again, then we cannot do anything. It's just that the regulation doesn't apply, and then he can utilize the genetic resource. So there's not a general prohibition about utilizing genetic resources as long as you don't know where it comes from.
Mm-hmm.
It's the opposite. As long as it's not sure that there's regulations for it, access legislation, you can utilize it. But the due diligence obligation um, foresees that the user, during
Mm-hmm.
the utilization tries to find out again and again at certain time periods in the frame of due diligence if he might get more information about the source. And of course, sometimes we can say, well, this is not well, it's always us who have to prove that the user is in the scope of the regulation. It's not the user who has to prove that he's not in the scope of the regulation. So that makes it a little bit difficult.
Mm-hmm. Yeah. Thanks. Just to note, sorry, I should have said this earlier, but I turned on the recording of this a couple questions ago, so I hope everyone's okay with that, if that's fine.
Yes.
So, does anybody?
Can I
Thanks, El.
can I quickly ask a
Yeah, yeah, yeah.
question to that? I mean,
Good.
do you know what the reason for it was to put it into declare? If I mean, it's probably something with a strain that was isolated in the 1960s or something, which is now going to the final stage of development. When you need to do that, this would not trigger this due diligence obligation normally. So is it merely by mistake or by being overly diligent or something like that, that something was entered into the declare platform?
No, actually, we didn't. We haven't seen such a declaration yet.
Okay.
We had once seen a declaration where somebody was declaring German genetic resources, and then we said again, you don't have to declare anything because Germany has no access legislation. So sometimes there are declarations which are not in the scope of the regulation, and then we just don't submit it to the ABS clearinghouse. But but we have never seen that somebody had declared something without telling the place of origin.
Okay,
Mhm.
thank you.
But I mean, I think this is also related to how the EU has set up their approach. And I mean, in different countries, they might be collecting this information differently at different points. They might set up their checkpoints slightly differently in other user or other countries. So yeah. Do you have experience with this at all, Laura? Like in other countries, asking like, I
Um,
mean,
eh, kind of. People are, especially from other countries, are asking me a lot, how is it done in Germany? And I can, tell them how it's done in Germany, but in some other countries, it's quite different, and it's not always easy to find out how it's managed. That's kind of my experience. But this would be done in the user countries, so in the other countries. But people ask me how it's done in other countries. Yes.
yeah. I mean, I guess like I asked you earlier, like where you guys are set up in Bayer. Like I guess you utilize genetic resources in other countries as well
Yes.
that might have outside of the EU.
Yes.
And do you have to deal with how is that dealing with their compliance and checkpoint? I mean, do you
Yeah,
have any?
that's
Yeah.
I'm not doing that. So I'm in
Okay.
contact with the people who are doing that in the other countries. But I'm more focused, on Germany. So I know how it's done in
Yeah.
Germany and what is supposed to be there.
Yeah.
But I can't really tell for other countries.
Yeah. Okay. Because it's interesting because we hear a lot about the EU and their setup, but it'd be nice to also hear more from other countries and how their approach is. But anyway, thanks for those comments. Other the other people on the call, feel free to also add any comments, or Beatrice, she's still there. Anyway, yeah. So the other question we had was, I guess this is about third-party transfers or transferring genetic resources to another person, how that is handled in the monitoring system. So I think like one of the ways that this can be sort of caught or whatever, like clear, is that when you issue a permit or an IRCC, you can, I mean, the person, their name, the entity of the person who has access is on the permit, right? And then you can also list conditions for transferring this to another entity or person or whatever. So that should be clear with the certificate and the permit. So, and part of the information that the checkpoint collects is who is there at the checkpoint providing this information. And if the person does not appear on the permit, or there's some like information that's not clear, when the provider country receives that information, they can make an assessment if that person was actually the person that was granted access, right? Have you had any questions about this, Ellen, or any issues?
Yes, during compliance checks, we had the case that some institutions, or I don't know if it was one or two, were not named on the permit. And so we got back to them and asked them, can you provide us with more information? Do you have anything where we can see that you were allowed to to be the ones who the genetic resources were transferred to? And we also addressed to the provider countries again. Was not during a checkpoint communique, but during a real user check. And then the permit was issued again, and then with the name of the third party, which was so it was solved the problem at the end.
Uh-huh. Yeah. I guess I think this is also a concern that comes up when we talk to countries, that their genetic resources are going to be like, they go back to the country, someone uses it, but then it someone else gets it, and they use it again. Do you think that is happening a lot, or you know what I mean? Is it or it's something that sort of can be um I don't know, contained, like working well to avoid that from happening?
So maybe I can comment also on that. So what I have seen on permits a lot from a lot of countries, I can tell for every country, but in a lot of permits or pick, there is stated that the genetic resource is not to be transferred to a third party, and you need to contact the yeah
Mm-hmm.
the national focal point again, or you need to reapply, or whatever is stated there. That's what we encounter a lot on our permits, and also when we get material transferred from third parties. And then to be compliant, in my opinion, you need to get back to the provider country anyhow, because it is stated, and you would be uncompliantly working
Mm-hmm.
anyhow. I don't know whether this is true for all the countries, but at least for a couple of permits where what I've seen, this is normally stated
Mm-hmm.
on the permit
Yeah.
itself, I think.
Yeah. No, I think so as well. I think that's pretty clear. I think it's just maybe a little bit I mean, maybe countries need some insurance that is being respected, because yeah. I guess the next question we get into, I mean, this is what they said, an example of non-respect, but I guess it means non-compliance. So I didn't have any on my side. I don't have any examples, but I just tried to list some ways to avoid this. So I think some of the ways to avoid this is the good communication between users and providers, because occasionally, like provider countries write to me saying, "Do I know this company? Have you heard of them? Can I trust them?" And I say, "Well, you should probably contact the person in that country, the focal point, and ask them, about this user, because I don't know." But I mean, I think said good communication and that should be encouraged between the authorities in both countries. I think like setting up ambitious but legal frameworks that include compliance. Like I said before, all countries are user countries and they need to implement the compliance provisions of the protocol. Um, uh, uh, Raising awareness among users is really helpful, I think. I guess, and then for the countries that are providing genetic resources, developing clear and straightforward access procedures and permitting systems will help users and to follow the legal process for access. I think including some obligations into the contracts for reporting is could be useful, and also making sure that the information is published on the clearinghouse. So I guess in a case of there's a doubt that something has been illegally used, again, I think Ellen has mentioned like this communication is important, and maybe like the first steps is trying to understand the situation, like you did in that example, and trying to maybe see how the user could be more brought into compliance, maybe reissuing a permit, like you said, which wasn't possible, and then I guess the final thing might be to penalize the user. So I don't know if anyone has any other comments they want to make about something like that?
Well, I would only like to agree that the most important thing is that also the user countries have the information. As I said, as long as we don't have information about the regulations in the provider countries, we cannot tell someone that he's not complying with the provider countries legislation. So yeah, as you said,
Mm-hmm.
the information is really the most important thing in order to make it possible for us to find non-compliant cases.
Yeah. Have you found like um I guess you kind of did like the case that you mentioned before, but like where someone has not been in compliance and then you brought them into compliance? Has that happened? Like were able to
Hmm.
reissue a permit, and it
Yes,
was, yeah.
we had this quite a few cases where countries were able to issue the permit retrospectively. So we already had set up a utilization stop and said you are not allowed to utilize the genetic resource anymore as long as you cannot present any information from the relevant country. And so they addressed to that country, and the country then issued the permit retrospectively. So the problem was solved, and they were in line retrospectively with the ABS regulations. And then the utilization ban was dismissed again, and so that was fine. In other countries or in other cases, we could not, the problem could not be solved, and then we had to set up fines. We have set up fines twice yet. And so, yeah, there
Uh-huh.
were, so there we had detected cases of non-compliance.
Mm-hmm. Okay. And is there anything else besides like you find them and then they're also, I guess, I
Yeah, there are different steps. So the first step
yeah,
is more the administrative step to say you have to stop utilization,
yeah.
and then we tell them to try to get the permit retrospectively. And then if in a certain time amount they are not able to present it retrospectively, a fine is going to be set up.
Mm-hmm.
And so it was, I think, 5,000 and 10,000 euros. So it was not very cheap. Um,
Mm-hmm.
and then the last, well, one step which would be very, very important, but is very difficult. Once the results of the utilization are published, it's not really easy to, to
Mm-hmm.
put this out of the world. I mean, they are there,
Yeah.
they are electronic. We did stop um, the distribution of some paperwork because we knew there was a publication on paper, so we have given them the prohibition to publish them any further. But once
Mm-hmm.
it's in the system in the internet, there's almost no way to to make a
Mm-hmm.
hint that this was utilized again by breaching ABS laws of the provider country. We tried to do this, but the publisher didn't react on it, and there's no legal measure for us to enforce it.
Mm-hmm. And when this happens, is it like in communication with the provider country, like they, or it's sort of
This
happening independently, or yeah.
It's a little bit difficult because we don't really see mm, a legal base to do
Mm-hmm.
this as concerns data protection. The regulation says we are allowed to publish the declarations on the ABS clearinghouse as long as it's not confidential. But we don't really see a possibility to inform the provider countries, and this is what we still have to discuss with other CNAs in the
Mm-hmm.
European Union.
Because I guess, I mean, a fine is something, but I'm wondering, like this information making it public. You know what I mean? Like that bad publicity is often quite huge, like a
Even worse,
huge,
yes,
yeah. So,
much worse than a fine, yes,
but I
probably.
mean, is it, you don't really make them public? That's what you're talking. Yeah.
No,
Okay, I
as
see.
we wouldn't go like
That
publish
far.
in a newsletter the name and the amount of the fine and
Yeah.
which country was. No, we are not allowed to do so.
Yeah.
And even the question if we can inform the provider country is
Yeah.
not yet really solved.
Mm-hmm. Yeah. Okay, that's interesting.
Can I get a second? Just a note. I'm not sure how many people in this webinar is like more reflecting the provider country side or reflecting on things that they need to do at home. But when we have the occasion, always remind that when you do your legislation to take into account the possibility of issuing permits and regularizing situations where there is a breach. So instead of thinking more on the punitive side from the provider country, I think it's to your advantage to actually do an effort to regularize when an identification of a non-legal access has been detected, so to ensure that the benefits are flowing to your country. So this is something to bear in mind.
Thanks. Yeah, thanks. The next one, I think this could be your question, Silvio, if I'm not mistaken. But basically, I think the question was, the European Molecular Biology Laboratory is an intergovernmental organization. Do you think that an international organization should be subject to monitoring obligations, compliance, etc., related to the Nagano Protocol? And I mean, I don't see why they would be treated differently from another user. And yeah, so I think they should be subject to, respecting the laws of the countries in which they operate, as well as the
Yes.
Yeah. So
Yes, yes, and this is what we are doing at the moment, of course, because there is also principle of national sovereignty that should be respected, of course, and also all the, let's say, more sensitive probably rights of related to traditional knowledge, etc. And on this, there is no doubt. I think. Thing is that is more on the due diligence side, I think, because international organization has this wonderful possibility to regulate internally some aspects of their activities. So, we are still assessing inside the legal team how this should be done, basically. So my question was more on that side. And of course, I don't have any idea in this of what also other international research organizations are doing, because it's a bit of different type of, we are different type of users, let's say, because we are not really, let's call us national users or commercial enterprises. I mean, it's something different, I guess. So my question was maybe more on that side. I know that it's not easy to give a reply, but actually I was also interested in taking part of this to learn more about the access and benefit sharing clearinghouse, etc. I also would like to tell you that we obtained also the first international recognized certificate of compliance from France. So, we are doing really huge efforts to be in line, let's say. But of course, this thing regarding due diligence is a bit different, in general. So, if you can give me some clarification on that side, it would be very helpful.
Yeah, thanks for your explanation. But I'm not sure I don't really see the difference there very much because, for example, Laura is here from Bayer, which is a multinational corporation, which is similar to an international organization. I mean, use is use, whether it's commercial or non-commercial, there still can be regulated. So I'm not sure how they would be very different, and I'm not sure how please, Beatrice.
Matt, I'm coming in. Well, I mean, I agree with Matt. Like, basically, I mean, whatever organization has to comply with existing laws. Like in general, not only ABS. Like whatever is the national framework, wherever you operate. This is like sometimes it's like no, the ABS is not so different from penal law. Like. But as an international organization, maybe it would be useful to think more about also having like internal guidelines or clauses or like something developed on that regard. And in the clearinghouse, I mean, there is other organizations that have done this before and that have created like an internal set of best practice or guidelines to help on their operations and even setting different sets of ambitions. You can go higher than the national laws if you want to comply, like in the clearinghouse, you can find it under Article 19 and 20, model contractual clauses and guidelines, things that have been developed by international, like botanical gardens, networks, and things like this to try to structure the internal operations. So there is some information there that you can consult, and maybe that could be useful to have a place to start.
Yeah.
And maybe I can also add, in the end, it comes to that, where is the actual physical genetic resource utilized in which countries, and where do compliance checks, what do compliance check comprise of? So in the labs that we have in Germany, the BFN, where also Ellen is working, does the compliance checks for the genetic resources we are utilizing in Germany. There is the same thing for France, and there's the same thing for Spain. That is depending on in which lab your samples are analyzed. You need to comply with the national obligations plus the international frameworks. Maybe it is difficult, but it is manageable with the right governance structure also.
Yeah.
Okay, thank you.
And I will follow up with some links for you from the clearinghouse that you can look into. As Beatrice mentioned, we have some information.
Yes. No, to me, it would be also relevant if you have any, material on experience that you have, I don't know, with the World Health Organization, for example, or other type of international organization that, are basically also compliant with Nagoya. So,
but I'm also wondering, I mean, I don't know if international organizations are the same as the UN, for example, like the WHO, and I don't.
Yes.
They might have slightly different I don't know. Alan, I mean, maybe have you ever dealt with international organizations in your compliance or UN organizations?
No, not yet. But well, what we could do is, if you're interested, then address us bilaterally, and we can see, since you're located in Germany, and see what you might have already done, or where you need any further help. And we have already worked with many institutions to set up, or to accompany them while they were setting up their internal policies or best practices. So we could do this as well.
Great. Okay, let's continue. Here's the next question. The real number of permits is not reflected as IRCCs in the ABS clearinghouse. How could the provider countries be encouraged to upload their permits and generate more? So I think this is a good question. I think it's something that we're also trying to work on. It's obviously a core obligation that parties have, and it's there for a reason because it supports this monitoring. So, I mean, we have a compliance committee that will look at these obligations, and another thing to highlight is that the success of the new Kunming Montreal Global Biodiversity Framework and goal C, particularly target 13, is measured by the number of permits that the success is measured on the number of permits that get published in the ABS clearinghouse. So that's another reason to do that. Um, a lot of countries have systems like databases where these information is stored, and what we're doing at the Secretariat is supporting countries to make their systems interoperable with the clearinghouse, so that the burden of publishing them, online is less and more efficient. So we're trying to support that. I mean, there's lots of capacity building resources and initiatives that are happening to support countries develop streamlined procedures, improved procedures to make getting permits easier for users. So that will, also support more permits happening. Yeah, I think in general, it's to the benefit of the provider country that they publish their permits. It supports monitoring, so it's not hurting them. It's actually supporting their work. So I don't. The other thing is countries that have permits sort of show off that they have a system working that can be attractive to users. So I just listed out some good reasons to publish permit. But in your experience, for example, Laura, I'm picking on you because you're there, but and there's only a few people. But I mean, how important is getting a permit for you, or getting a certificate for you from the clearinghouse rather than having the permit?
So I mean, we get the permit, and it is also published on the we get it, but it is additionally published on the clearinghouse. I don't think it makes such a big difference whether or not it's really there. I'm always happy when I find it published on the clearinghouse, the permit itself. But there are also a lot of different countries. I'm thinking, for example, Brazil, where no such thing as IRCC is really existing, but it's more like a registration in a database. This is not reflected in IRCC. I think we have it internally stored in other databases as well, not only on the ABS clearinghouse, but nevertheless, I do think it is important that it is there and it is visible. I think also, for example, South Africa has it also published on their Biodiversity Institute, a list of their IRCCs, which is sometimes a little bit more visible, because sometimes I think when you scroll down on the IRCC, we really need to click to it. You don't have the filtering option or something. So if I want to scroll through the South African IRCCs that have been published, I would rather go to the Biodiversity Institute itself. But I mean, we have it doubled anyway. So
Yeah. Okay. Ellen, I mean, do you have anything on this? Like, do you encounter like people are users that don't have certificates, and does that cause problems or not, or how?
Well, as long as they have anything, it's okay. But of course, the IRCC is the best proof that they are compliant, because it's easy to see what's in it, and it's easy to compare with the information we have from the user. And so, yeah, the IRCC is like the best permit. I mean, the best proof of a permit. Yeah.
Okay, good. Thanks. So another question that's sort of related is how effectively can you use the ABS clearinghouse to monitor utilization when only relatively few countries are uploading permits and information on checkpoints? So, I mean, my answer to this is that the ABS clearinghouse is not a substitute for national implementation. It's not like it's something magic that's gonna. It's only a platform. It's a tool that needs to be used to make it valuable. So. But I'm on the positive side. Parties have made a lot of progress in the last few years in setting up their frameworks and their systems and operationalizing the protocol. A lot of countries have operational compliance systems. I mean, Ellen is a very good example of this. Yeah, and more users are setting up like, I guess, internal compliance and compliance people, officers, and they're more and more aware of obligations of the protocol. And we've also had some voluntary sort of checkpoints. For example, there's the Journal of Molecular Biology. I don't know, maybe you've heard of them, but they are also requiring their researchers who submit articles to have IRCCs, and they're doing some sort of check to ensure that they're compliant. So there's positive things happening. So what are some of the shortcomings of this mechanism? And I just sort of reiterated, we had a few years ago, Ellen, you were there at that global monitoring meeting in Bonn in 2019, but we sort of highlighted there some of the key issues that are happening, particularly with monitoring. So basically, there's a lot of lack of understanding on the protocol system to monitor in a lot of countries. Like there's misinformation, mixed up ideas about what checkpoints are. A lot of there needs to be there's just a general lack of understanding. Again, countries are all in different stages of implementation. They ratified at different times. People are starting their sort of process. Some people are more advanced. So there's all this, you know, difference in countries about where they are operationally. There's a lack of capacity, financial resources. I mean, I'm sure you have experience dealing with this, trying to deal with countries. Yeah, there's a lot of internal coordination issues. There's some countries also don't know when exactly a permit is a permit, and they sometimes they just have the pick, sometimes they have the mat. They don't know with research counts as or they think maybe just it's commercial use is considered a permit. So there's a lot of misinformation going around. Yeah, and I think a lot of countries, I mean, I know some countries that don't have, for example, electronic systems. They don't have databases. They do things on paper. It's in a file. It's very there's a lot of real practical challenges to set this up. But so it's one of the last. I mean, it's a tricky part of the protocol. It's an innovative part of the protocol, but it's also tricky. Anything here? Okay, let's go on. There was this question that came up that I didn't know how to answer, but in which databases can suppliers of genetic resources search for their use? So I wasn't really sure exactly what, I don't really know, except for like, if you look in like journals and like, I guess patent applications and things like this, maybe you can find out more about the use. I know that in under Article 8J, there's some work to encourage databases to be set up of traditional knowledge related to genetic resources and cataloging that and store and saving, but I don't think they're accessible. So I don't know what they were trying to ask for here, but I think it's
Well,
sorry, go ahead.
Well, I think actually we are facing quite the same problem as a compliance authority, because we also do not have a clear source where we know, okay, there's every user of a genetic resource is in this database. So we just look at this database and we know, okay, company XY is utilizing genetic resources, or we just don't. There is no official information about utilization of genetic resources. And so it's not only a problem for the provider countries who then do not know what's happening with the genetic resources, but also for the compliance authorities to find out what kind of utilization of genetic resources takes place in its country. And I think actually the database is the clearinghouse then, or it's the information platform where the checkpoints communiques are collected, but there's not yet any other information pool where you get such information. So what we are trying to do for the next years is to set up some kind of IT tool that, you know, it's like artificial intelligence, using artificial intelligence. So this tool should learn by working for itself and trying to get information, as you said, from patent databases or research publications, and any kind of information which is there to like search for relevant utilization of genetic resources, because by now it's very difficult to find out what utilization takes place, and even more because we do have the condition that the utilization must be in the scope of the EU regulation. So it's not every utilization of genetic resources that might be easy, but it's utilization in the sense of the EU regulation with genetic resources which were accessed as of 12 October 2014. They are from a party to the Nagoya Protocol, and this country has access legislation. And those are some conditions which are very difficult for even for us to find out about, because we don't have databases where we can look in and say, oh, okay, there we have this company, let's have a look if they are compliant, and then we have this institution and let's see if they are compliant. So yes, it's not only difficult for the provider countries to find out where their genetic resources go to, it's also difficult for us when we do compliance checks. So, so that's maybe some problem in the system.
I wanted to add to this, I mean, that basically, yeah, I mean, has been some initiatives doing these IT tools that crawl in patent databases and looking at different sets like the Biopiracy Commission in Peru, I think India, I think has been some works with Paul Oldham as well. But the idea, I mean, and this was an idea and a concern that was all the time, like when we were negotiating the Nagoya Protocol, how do you ensure compliance, how you track that users are not. But the solution that was crafted was this monitoring system to try to replace this humongous task of like searching all over the place the utilization of genetic resources every time that something is mentioned and is coming from your country or not. So what we encourage sometimes, I mean, we encourage countries to set up their ABS systems, set up their compliance systems in place with the permits, the checkpoints that are effective and that work, because ideally that would solve that issue. And well, let's hope maybe artificial intelligence and all this technology maybe can help us later on. But sometimes you cannot ask complicated questions as you are like as you are put straightforward even doing that. So I encourage everybody to focus on setting the systems as it was on the protocol, because they were trying exactly that problem.
Any other comments? Okay. Well, this is the last slide. So the one was just someone made a comment that they need training. So I sort of wanted to reiterate that there's e-learning modules that we have for countries to help them set up and establish their legal frameworks. There's some capacity building material that we can make available. I think it's important that countries communicate their needs, so what their problems are, do some, investigation to be able to articulate that well. There's trainings, there's learning from others, and I think important as well is to learn by also doing. So that's pretty much it for the things. I mean, maybe if you want, since we're such a small group, we can also have any particular questions or interest that you want to talk about. Is there anything else from Silvio, Laura, Andre, or Eliska?
If you cannot talk, you can put it in the chat if you want, Eliska. I don't know if you had problems with the mic, but if you add in the chat, we can ask the question for you. Also, Andre, the same.
Is there
otherwise,
maybe one, if we're talking about the ABS clearinghouse that has nothing to do with monitoring utilization, is there planned a next round of this interim reports on ABS implementations? I think it was 2017, 2018 when it was last this this questionnaire to the respective countries. I think it's always very useful, but a little far away for now. Is this planned somewhere in the future?
Yes, unfortunately, I mean, like there was this thing called the pandemic, total delays, has been, so all our schedules of meetings and reporting was thrown, anyway. So the last meeting, they decided that the next report would be due in February 2026.
Okay.
So it's very far away because the idea was to fit in the midterm review of the next strategic plan. So they were trying to make all the results of it to fit in different review process of the coming global biodiversity framework. So yeah, it's going to be in a while, but as we say, we are trying to encourage countries to update information. We are doing a lot of things to try to make that the ABS clearinghouse is up to date, to provide that information in the meanwhile.
Okay.
Yeah, it's unfortunate.
But the important thing is that it is planned.
No, it's planned. Normally should be every 4 years.
Okay. Good.
But this has been a very exceptional circumstance, I have to say.
Understandable.
So we have a question. There is a question.
Oh, yeah.
Thanks for your clarifications. We have a specific case where we have in our database information about the use of our country's resources in another country, but we didn't give permission for that. It would be useful to learn about effective algorithm for dealing with such cases in other countries.
Yeah. I mean, I would suggest that you contact that country's authorities and discuss this case with them.
Yeah, and contact the countries and contact the whoever you have
the user. Yeah.
The information on the user. If you have the information on the user, contact the user, contact the country where that user is located, and try to engage for regularization of that use. That would be my suggestion.
Thank you. Good. I know we're getting more and more on past the time. So, I mean, it's very unfortunate. I'm sorry there wasn't more people. I think there must have been like some mistake I did when I sent out the invite. But in any case, as I said, it's very nice to meet you. It's very nice to see you. I like part of this is to also interact with people and hear, actual experiences of people working at ABS, which is sometimes difficult for us at this global level at the Secretariat. And so it's very nice that you joined. And so please don't hesitate to write to us if you have additional questions. Thanks again, Ellen, very much for your providing some real experience. I think that's very interesting and helpful. And all of you actually for doing that. Anything else before we go? Say goodbye. All right. Well, have a great day, and
Have a great day.
I'll
You
let you
too.
know
Thank
of the
you.
next webinar soon.
Okay, great.
Okay.